So 17 states just joined Gun Owners of America in their lawsuit against the ATF and the ATF's new rule on frames and receivers, which will take effect in mid-August. So let's talk about this. But real quick before we jump into this video, if you think that the ATF needs to be abolished, go ahead and hit that like button and subscribe. Also, I want to thank the sponsor of this video, which is Zenith Firearms. Founded in 2014, Zenith Firearms is a family-owned and operated manufacturer based out of Virginia. Zenith has a team of more than 50 engineers and manufacturing specialists who are responsible for creating products like the ZF5, which is currently available for pre-order at Zenith's website, with a delivery expected about the third quarter of 2022 this year. So if you're interested, check out Zenith's website. You can check out the ZF5 and get more details on that. And once again, I want to thank Zenith for sponsoring this video. So like I said in the intro, 17 states just joined Gun Owners of America as plaintiffs in their lawsuit against the ATF and the ATF's new rule on frames and receivers, which is set to take effect in mid-August, so here really soon. We all knew that the ATF was going to be sued because of this new rule on frames and receivers, but now 17 states have signed on as plaintiffs in this lawsuit against the ATF and this new rule. I want to emphasize that this is actually really significant because we do not often see states on a large scale joining in on lawsuits against an agency as actual plaintiffs. Sometimes we see these individual states sue an agency like the ATF. We've seen this with the Texas Suppressor Freedom lawsuit where the state of Texas is suing the ATF. And sometimes we also see these states join together in amicus briefs, but it's really rare that they will actually join in as plaintiffs in a lawsuit. And here you have 17 states joining together to become plaintiffs in this lawsuit against the ATF and their new rule on frames and receivers. The 17 states which joined GOA as plaintiffs are Arizona, West Virginia, Alaska, Arkansas, Idaho, Indiana, Kansas, Kentucky, Louisiana, Missouri, Montana, Nebraska, Oklahoma, South Carolina, Texas, Utah, and Wyoming. So those are the 17 states. Now, if you're not aware what this lawsuit entails, this is a lawsuit against the ATF because of their new rule on frames and receivers. This new rule by the ATF is essentially a restriction on the sale of 80%er kits. Under this new rule, 80%er kits are treated as firearms. This new rule went into the regulatory definition of a firearm and changed the definition through a web of references and referring from one section to another section so that it is including into the definition of an actual firearm 80%er kits. Since 80%er kits are now considered to be actual firearms, they're going to be subject to serialization requirements and background checks as well. Under this new, the primary impact will be on gun stores and gun manufacturers of these items. An FFL or gun store will now be required to serialize 80%er kits or privately manufactured firearms that come into their possession, and they will also have to serialize their inventory of 80%er kits once this goes into effect before they could ever sell them. And also the burden will be on them to have to run those background checks on any sales of 80%er kits after this rule goes into effect. So going forward after the effective date in August, you will only be able to purchase an 80%er kit from a gun store if the item has a serial number on it, and also only if a background check is run on you and that purchase. Now, the last thing that this final rule did is it changed the retention of records requirement. The rule states that FFLs must now maintain firearms records indefinitely instead of just the 20-year period. This has brought a ton of concern because eventually the ATF will get their hands on almost every firearms transaction that goes through a gun store because there is no longer a requirement that you only have to maintain it for 20 years and then you can destroy those records. So that is a general rundown of what this final rule on frames and receivers did, and that is what is being challenged here in this GOA lawsuit. This case was originally filed in the North Dakota District Court, and in the first section of the complaint, I want to actually bring to your attention was the type of cause of actions that are being brought, and the first one is the separation of powers. GOA states in their complaint that the final rule is invalid because the final rule represents an attempt by an administrative agency, the ATF, to implement policy change and enact omnibus federal gun control legislation through bureaucratic regulation rather than through legislation. In this section, they hit on the important distinction that a regulatory agency is not supposed to create legislation. Instead, that is the job of Congress. Now, this section I think will eventually be also added to down the road based on a recent Supreme Court ruling in West Virginia v. EPA. In that case, the Supreme Court found that Congress did not grant the EPA authority to regulate greenhouse gas emissions virtually any way that they want in any industry. The Supreme Court, in reaching their decision, found that the case involved what is known as the major question doctrine. Under the major question doctrine, when an agency's interpretation of an ambiguous statute concerns an issue of vast economic and political significance, the court must deny the agency the deference traditionally afforded to them under a different doctrine, which is known as Chevron deference. So the West Virginia case was important because it drastically limited the ability of an agency like the ATF to be granted deference to enact rules like this. Instead, under the major question doctrine, the only way the ATF could do something like this is if Congress expressly gave them the ability to do it. And here, Congress has not done that. So I would predict that this new major question doctrine will pop up at some point during the litigation of this case and will be used against the ATF. The next major aspect of the complaint I want to bring your attention to is the discussion about the recent Supreme Court ruling in Bruen. In this section of the complaint, GOA pointed out that the entire basis in which the new rule on frames and receivers was created upon is the interest balancing approach, which the Supreme Court just struck down. In the complaint, they say that the final rule expressly said that it was created on this interest balancing approach and that they have a governmental interest in regulating privately made firearms, and that it is in the best interest of the public for them to promulgate this rule. Since the final rule's findings and conclusions are contrary to the law as recently announced by the Supreme Court, the final rule must be struck down. And they state that certainly the ATF is free to try once again and to re-promulgate new final rules and to take into consideration the Second Amendment implications that were outlined in Bruen, which is text as informed by important history or relevant history. But essentially they're saying the basis that the final rule was created upon is no longer valid and that this new rule should be completely struck down by the court. If the ATF wants to have a new rule like this, they have to find some sort of historical analog dating back to 1791 to justify this new rule, which is going to be very hard for them to do. Now, after the original complaint was filed, the additional 17 states joined in the lawsuit against the ATF. They also filed for a notice of joinder in the motion for a preliminary injunction and a motion for a permanent injunction. A notice of joinder is simply an alternative to filing a motion seeking relief on the same grounds as a motion filed by another party, here GOA. The joinder simply asks the court for the same relief already requested in another motion, but in the name of those joining parties. So essentially the 17 states also are requesting a preliminary injunction and a permanent injunction against the enforcement of the ATF's new rule on frames and receivers. So the states are arguing that not only will the new frames and receiver rule cause severe and ongoing injuries to the constitutional rights of state residents, but also it will cause unrecoverable financial injury to those states who gather tax revenue on the sale of those items. And because of that, they argue along with GOA that they are entitled to a preliminary injunction against the enforcement of the ATF's new rule on frames and receivers. If granted, the preliminary injunction would bar the ATF from enforcing the new rule on frames and receivers until the end of the trial. Currently, the new rule is set to go into effect in mid-August, so we should see sometime really soon some more movement on the preliminary injunction, and we will see whether or not the court is actually going to grant that preliminary injunction and bar the enforcement of that new rule on frames and receivers before it goes into effect in mid-August. So I think this gives you a good idea of some of the main arguments made by GOA in their complaint, and those arguments also made by the 17 states who have now joined in on this lawsuit against the ATF and their new rule on frames and receivers. Like I said, it's really a good thing that the 17 states signed on as actual plaintiffs in this lawsuit. That rarely happens, and it really does add to authority of why this new rule by the ATF is so unconstitutional. So I definitely want to give props to GOA who filed this lawsuit and also to the 17 states that have now joined in this lawsuit. And I really look forward to them pretty much just smacking down the ATF and finally stopping them in their overreach with these types of rules. So if you guys have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Algorit's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of two-way news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, helping me to reach and educate more people than I could ever do on my own. So again, thank you so much for all of your support. And as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this is Built by Armed Scholars, and this nation will be maintained by Armed Scholars.